Morning. Next case is N.M.W and A.N.D, and we will hear from the appellant.
Honorable Chief Justice Newby and Honorable Associate Justices, may it please the Court. My name is Stephanie Sanzoni, and I represent the Carteret County Department of Social Services, appellant in this matter before this Honorable Court. I plan on sharing my time equally with appellate counsel for the guardian ad litem, Ms. Maya Engel. We are requesting 4 minutes of rebuttal. I want to thank the Court for this opportunity to be here today. This is a case that I have lived with since 2019, and it's a pleasure to bring it before this Court. This matter comes before this Court today on a split decision in the Court of Appeals with a reasoned dissent by Judge Stroud. In that decision, the Court of Appeals vacated a permanency planning order where the Court seized reunification efforts on siblings Nora Ann as to the mother, Rebecca Day. As a result of that decision, the Court also vacated the termination of parental rights order. That order had been granted on 4 separate grounds, and this Court granted discretionary review and stayed the Court of Appeal decision. Ann has been in the custody of my client since 2019. And her half-sister Nora since 2020. That was done 2 days following Nora's birth. Both children are currently in pre-adoptive placements today, and this appeal is the final barrier to their adoption. It is appellant's position that the Court of Appeals majority decision is in direct conflict with this Court's opinions, and those are specifically LL, LMT, and LRLB.
So I apologize for stopping you there, but you touched on a point, and in your brief on page 13, you've touched on an issue that I've been thinking about for some time now, and it's good to have a practitioner from the trial court be able to hopefully help with this. So what do you think the effect of this opinion, this published opinion, is on the practice of juvenile law across North Carolina?
Well, thank you for that question, Justice Berger. This opinion will cause, in practical sense, a lot of confusion for the trial court. As this court has opined previously, that in appeals of the permanency order seizing reunification, that the court should also be looking at together the termination order. And in this instance, with the termination order having over 71 findings of fact, I think that it was the intention of the legislature, as well as and this court's ruling as well, that to disparage or finalize, remove that termination of parental rights proceeding after all of the time and energy that the court has spent in ensuring that all of the factors have been met, all of the findings are ample.
Well, and I apologize for cutting you off, but
yes.
So my question is a little bit more grounded in some of the work that we do on a daily basis, which is we issue an opinion which vertically, in terms of vertical stare decisis, ought to settle an issue.
Yes, sir.
Right, and you said that the Court of Appeals opinion could cause great confusion across the state for practitioners.
Yes, sir.
And my question is, what do we do about that? When this court has issued an opinion and the Court of Appeals appears to have issued an opinion that is at odds, how should we handle that?
Your Honor, the fact that this court has allowed us to have discretionary review is obviously one of the remedies. But unfortunately, what that has done is delayed permanence for these children. What I would ask this court to do is to reaffirm its decision in Ray LL. The mere recitation of statutory language is not only onerous for those practice the law and draft the orders for the judge to review, it becomes almost a game of trying to figure out exactly what each panel or what each judge in the Court of Appeals is
Right.
requiring.
Right, and that's where I'm going with this. Do you think it would be helpful for practitioners across the state if we were to say that any Court of Appeals opinion issued in 3.1 cases shall be unpublished and shall have no binding effect? The only precedent that has binding effect are opinions from this court. And it would seem that that would allow the law to percolate, and as opposed to causing uncertainty in the law, it would allow trial judges, instead of one side saying, this opinion came out last week, it would allow trial judges to essentially use judgment instead of being perhaps influenced inappropriately or improperly.
And Your Honor, I think that that would be the most helpful thing to do. We as practitioners are trying to ensure that we hit all of the factors, obviously all of the elements that are required, that our orders ensure that all of the findings support the statutory factors. And each time it seems, Your Honor, the Court of Appeals has something else that requires us to maybe put something else into that order. And in this case, with these children having been in custody and care and with a finalization of adoption that could occur almost immediately, it has now rendered permanency even further. And these children now, one of them just celebrated her 6th birthday.
And I apologize for derailing your argument.
Not at all, Your Honor. I appreciate that. From a practitioner's standpoint, I appreciate that.
Well, I guess while we're stopped, and I just had one question. If
Yes,
we
sir.
were to agree with you, and so we would reverse the decision of the Court of Appeals, are there still arguments challenging termination for the mother that would need to be addressed by the Court of Appeals, or?
No, sir.
Okay.
In fact, in the mother's stance before the Court of Appeals, there were no challenges to any of the findings or anything in the termination order. So if this court were deemed to just affirm the trial court, that would complete this case and for the purposes of moving this
Okay,
case.
that's all I wanted to affirm. Is it didn't seem to me there was anything left over.
No, sir.
at the
And in
Court of Appeals.
fact,
There's not. Okay.
excuse me, Justice Teesa, I apologize, but in fact, the only 2 challenges in the permanency order was one concerning, and number 15, concerning whether or not the court properly took judicial notice of the underlying court files, which is very common in juvenile law because the cases span for such a long period of time. And until recently in Carteret County, with our 1 judge, 1 family, prior to that, there could be 4 or 5 different judges hearing 1 case. So that's a necessary thing that is required in at least the practical sense. The other challenge that that my friend had was in number 61 of the findings, and that was as to reasonable efforts. And the Court of Appeals did not even look at that challenge. Judge Stroud did, and found that there was ample evidence to support that, but the Court of Appeals did not. I did, and if there were no other questions about that, I'd just like to go a little bit into the facts, because this is such a, almost a travesty at this point. These 2 siblings have been in their pre-adoptive placement for some time. At the time of the termination, which spanned over 3 days, the court provided the mother ample opportunity to cooperate, provided ample opportunity to be a part of the proceeding, and the court also noted that not only the mother, who is the subject of this appeal, but the father whose rights were terminated, and that was affirmed by the Court of Appeals, that they continued to delay and stall. And that's something that happens a lot in these juvenile cases. The facts, and I know my colleague is going to go a lot into the facts, she represents the children, but what has been difficult in trying to articulate an argument in this case is the scant findings in the Court of Appeals. And the court summarily just decided that under 906.2D, factor 3 and 4 as to availability and as to whether or not reunification efforts would be successful, just summarily said that they were not met. And I posit to this court in the over 9 pages of findings that there is not even a need to parse. They are fully set out. And
So you interpret that to mean the Court of Appeals, to get to Justice Berger's point, you think the Court of Appeals majority just mistakenly didn't understand the rule from LL, thought there needed to be language that tracked the precise wording of the statutory factors? Is that what you think was the reason?
I would have to assume that, Your Honor. I mean, in the Court of Appeals decision, the Court of Appeals does cite LL, but then totally, in my opinion, ignores what the holding of LL is. If the court were to take what the Court of Appeals in this case is requiring, you would need to put almost a heading in each order and have the findings under that.
Because your point is if the majority thought, well, what we need to do is look at what's said in the actual fact findings and assess whether, so essentially what we were saying you would do in LL, or what, to my understanding, is what the dissent was doing, they would have done that. And then by not even doing that, we can at least infer that they were looking for particular words and thought that that was required.
And Judge Stroud indicates that in her dissent aptly, that it seems that they were just searching for the word available and the word inconsistent, and were not able to determine that phrases like inconsistent or came to a drug screen or participated in a child family team meeting did not equate to that. And so the only thing I think, Justice Dietz, is to infer that the Court of Appeals was looking for specific language. And In re LL is exactly the opposite of that. And I think provides the court to give deference to the trial judge, who in this case had presided over this case for almost 2 years, so knew this case intimately. It was not a judge that was taking over from another judge. So that is something that makes the practice more complicated and difficult than it needs to be, and frustrates the purpose of the juvenile code. I will also point out that the fact that the court did not even review the termination order together with the permanency planning order indicates that the holdings in this court were not even reviewed by the Court of Appeals. It's difficult, as I indicated, to articulate an argument. There's so much to say, but when the Court of Appeals opinion is just such a summary of it's just not there and we're going to vacate, is frustrating and makes the practice very difficult. I will, to that point, Your Honor, I will say that the remedy, if in fact this court finds that the Court of Appeals majority was correct, and the remedy is vacation of those 2 orders, I think that's a miscarriage of justice as well. This court has specifically held that if the error is not material or prejudicial, that the proper remedy would be remand back to the trial judge. The trial judge was the one that heard this case. The trial judge was the one that drafted and allowed all of the findings in the orders. So to vacate the review, the permanency order, as well as the termination order, is silly. I can't think of another word except for silly. The proper remedy, and this court has already indicated that, is a remand, but we posit that that's not even necessary. So unless Your Honors have any questions or anything, I'll have my colleague.
Thank you, counsel.
Thank you, Judge.
Chief Justice, Associate Justices, may it please the court, I am Maya Engel, and I am here on behalf of Anne and Nora as the guardian ad litem appellate pro bono counsel. While I'm here, I'm not going to belabor any of the positions that we've just talked about, but I do want to make a couple of points that I think are responsive to the questions asked. I'd like to start by saying Anne was 8.5 and Nora was 2.5 at the time visitation was suspended with their mother. At the time of termination, they were both progressing and thriving in their placements, and that is why I'm here to support the position that we've already advanced, that the Court of Appeals opinion should be overturned as it relates to Ms. Day. I'm going to discuss 3 main points and weave in the questions that you've already asked. First, the trial court clearly established that reunification would be unlikely in this circumstance, unlikely to be successful, which is the ultimate finding needed under our current precedent. Second, the trial court's orders, whether reviewed either separately or together, satisfy all of the statutory elements to cease reunification, and Judge Stroud's dissenting opinion gives us great guidance and a valuable roadmap for this review. And third, the Court of Appeals decision as it stands would be a harsh remedy and not only will negatively impact Anne and Nora, but children who are in similar positions. So I'm going to start by addressing the questions Justice Berger and Justice Dietz raised related to sort of the confusion and the impact of these cases as it stands right now. And just thinking about it quickly, the Supreme Court briefly did have exclusive jurisdiction over these cases. And when that was removed by the General Assembly, the general thought was that getting the cases out of this court was important. However, I kind of like the proposal that is suggested as an appellate pro bono counsel, not as a practitioner as well, that gives guidance even to appellate counsel as to how to weigh the Court of Appeals opinions like this that seem to have completely missed the mark as far as precedent. And I would say that I believe that not only did they miss the mark on LL, but LRLB and numerous other cases in this court's precedent that suggest that we do not have to use the specific words as long as we're finding generally what the statute requires. Uncontested at this point are sections D1, D2, and I would also say D4 since Ms. Day did not challenge D4 before this court specifically. So as we go, standing alone, I think the uncontested findings in both permanency planning and termination order paint a picture of why reunification with Ms. Day will not be successful and why additional time and services will not warrant a different outcome. As an example, and without going into too many details or throughout the entire history of this case, the events surrounding a trial home placement really are illustrative of this ultimate issue. At one point in 2021, and according to an April 23rd, 2021 case report, Ms. Day and Mr. Wolford made enough progress and the children were thriving in their foster situation. So the trial court authorized a trial home placement. First with 7-year-old Anne, and then a month later, 1-year-old Nora followed. The guardian litem was very in support of that trial placement and reunification efforts. Once the trial home placement began, early indication was that it was going well, especially when it was just Anne in the house. When Nora joined, the family started settling into a family of 4. Within weeks after positive DSS report indicating that the situation was going well, things started to deteriorate quickly. Ms. Day and Mr. Wolford began to restrict DSS and GAL's access to the home and to the children. And then abruptly, the trial home placement was disrupted due to safety concerns on the 4th of July. DSS reported that they received reciprocal allegations of domestic violence with each Ms. Day and Mr. Wolford against each other. DSS also reported they received a later found not to be substantiated report of Mr. Wolford sexually abusing both Anne and Nora, which is something that had happened in previous times in the court as well. Ms. Day and Mr. Wolford recanted their story quickly and later submitted their own court report, each one minimizing the incident and attributing the disruption to stressors such as illness, work schedules, and the need for respite care. While those stressors may be real, reunification cannot hinge on whether parenting is convenient. When the trial home placement was granted, it appeared this case was headed to an outcome that represents the shared goal of every child welfare case: safe reunification of children with their parents. But when a trial home placement fails, the consequences for children are significant. Until that point, there was no indication that Nora, who entered non-secure custody just 2 days after her birth, had ever experienced a home environment marked by fear and instability like her sister had. After the disrupted placement, both children exhibited behavioral changes. Nora began to display fear around Mr. Wolford while clinging to the social worker and crying at visits. Anne, meanwhile, had a strong regression, ended up being involuntarily committed for mental health issues, and had to be moved to a therapeutic foster home. She regressed in therapy, developed nightmares of being back with Miss Day and Mr. Wolford and of them hurting her foster families, and no longer identified Miss Day as a safe person, which is in a permanency planning order in March of 2022. The disruption of that trial home placement marked a critical turning point, not only in the procedural posture of this case, but in the lived experiences of the children. Many of the same concerns that had persisted throughout the life of the case were identified as still existing, including allegations of domestic violence, Mr. Wolford's exertion of control over Miss Day, both parents' continued denial that any problems existed, their tendency to blame others for the circumstance they faced, Mr. Wolford's repeated inappropriate and disrupted behavior toward foster parents, the department, the guardian ad litem, the court, and other professionals involved, and Miss Day's inability to disengage from that controlling relationship. Taken together, these circumstances demonstrate that the failure of reunification was not episodic or situational, but systemic, and unresolved despite years of intervention. The trial court's findings in the permanency planning order established a lack of meaningful progress, and that Miss Day, as Judge Stroud pointed to in her dissent, was merely checking boxes on her case plan and not making meaningful change, considerations that independently support the cessation of reunification efforts. When given the opportunity for support and resources to make changes, Miss Day continually chose herself and Mr. Wolford over Anne and Nora. Turning to my second point, even though not required under LL, the trial court here did make findings that infer that Miss Day was or was not available as identified in subsection D3. This is also different from the case in LL where the findings themselves did not include availability, but instead referenced a prior report. As Justice Stroud noted in her dissent, availability was not the true barrier in our case. Our joint brief outline on page 18 outlines some of the key findings, some, not all, showing Miss Day's availability. 3 of them relate to her attendance at court proceedings, 4 concern her interactions with DSS, GAL, and the trial court, and 3 address her progress or lack thereof on her case plan. LL and LRLB have both given us some guidance to show that if some of those findings were found in those cases in the findings of facts, that would be enough to suggest availability. This court has never required and should not require a rigid checklist of facts demonstrating availability, and to the point earlier made by Judge Dietz, the usage of the actual word availability. That being said, excuse me, to do so would contravene this court's guidance in LRLB, which rejects hyper-technical requirements for statutory findings. That brings us to the third and final point, which we've already touched on briefly, related to the confusion that this case would cause if the Court of Appeals opinion stands. It would also create more uncertainty for Anne and Nora. Vacating a permanency planning order and thus a termination order is a drastic action that requires a showing of material and prejudicial error likely to affect the outcome. Miss Day cannot make that showing here. The Court of Appeals majority provided, as we mentioned, only a brief analysis of this case, and of her case in particular, and failed to clarify why it believed the trial court's statutory findings and conclusions were insufficient, including from numerous reports and prior orders and the extensive record supports its determination and shows it did not abuse its discretion in issuing the permanency planning and termination orders. Judge Stroud, in dissent, noted Ms. Day's decade-long involvement with Child Protective Services across several states and lack of progress despite extensive support. The record shows no likelihood that more services would alter the outcome. Ms. Day has not accepted responsibility for Ann and Nora's removal. She has only superficially complied with her case plan. She's denied domestic violence despite numerous reports where she has made allegations against Mr. Wolford, and continues to live with Mr. Wolford. Under these circumstances, vacating would serve only to delay the inevitable and further prolong Ann and Nora's opportunity for the stability and permanence they deserve.
And Counselor, I realize you are getting near your rebuttal time. You mentioned delay. Can you estimate for this court how the appeal to the Court of Appeals based on these facts and their holding, how much that delayed the permanency for these children?
Yes, so the termination of parental rights order was in May of 2024. So we are now almost 2 years past that date.
Thank you.
Yes. All right, if no further questions, I'll reserve the remainder of our time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Good morning, Mr. Chief Justice, Associate Justices. May it please the court. My name is Jason Sendes. I represent Respondent, Appellee, Respondent Mother in this matter. We are standing today to ask that you affirm the Court of Appeals opinion, which found that the trial court failed to make necessary findings under North Carolina General Statute 7B 906.2D. These cases, like all cases arising out of 7B actions, are inherently emotional. Friends at the other table have put a lot before you to pull forth that emotion from your honors. These are inherently complicated. The size of the record shows how complicated they truly are. And it's because of that they're incredibly fact specific. I believe that is why the legislator specifically put forward 906.2D to give a trial court proper direction to take the significant step of ceasing reunification efforts with a parent. There's been a lot about the children. This case is, of course, about children. It is also about parents. That is the purpose of 7B. It's to protect the rights of both the parents and the children. That's our guidance here. So while I can understand the concern about the timelines and how long this is for the kids, it is also important when looking at 906.2D that we're looking at, was the proper procedure taken to take this step? Because this step is not simply, did the court go through 906.2D and did they check boxes? Did they use specific language? This is about a respondent mother who was deprived of her right, as the Court of Appeals said, statutorily mandated right to reasonable efforts from the county towards reunification. The timeline, I think, is important here. The hearing, the permanency planning hearing, occurred in April of 2023. The order was not entered until November of 2023. A TPR began, and the TPR order was not entered until May of 2024. It was a full 13 months from the time respondent mother had her reunification effort ceased until her ability to even come before an appellate court. That may be distinguishable from the other courts. If you look at the precedent, if we look at NRA-LL or NRA-LR-LB, the timelines are shorter. So specifically, jumping a little ahead to the second point about what is the proper remedy, just to try to answer some of the questions today, with LR-LB, the timeline is significantly shorter. Not mistaken, that PPH occurred in October of 19, and the order was entered March of 2020. Came before this court in 2021. So that's the amount of time we're dealing with is significantly more, which is why the appropriate remedy, as the Court of Appeals said, is for it to remand back. Stepping back to whether or not the Court of Appeals was correct and whether or not the necessary findings are there. It is true, as I've put in my brief, this court has stated you need not simply cite 906.2D. But it's the essence. It's I believe it is the issue embodied is the term used in LRLB. The issue embodied in that statute. And that statute is telling trial courts, you need to look at these things. You need to consider these issues because this is what is important. This trial court permanency planning hearing, I do not believe addresses it. It need not state available, unavailable. That's openly conceded. The Court of Appeals referenced N.R. LL. So did the Court of Appeals know of N.R. LL? We can see right there that they in fact did.
But you would acknowledge, so if you had written the Court of Appeals opinion, just having read your papers, I don't think you would have written that opinion. You would have analyzed the findings and rebutted what Judge Stroud was saying by pointing out this just isn't sufficient, and the purpose of making the findings is to show why to cease reunification, and none of these would satisfy the statutory criteria. But that's just not, this opinion really reads as if it's like a magic words opinion, it seemed to me.
Your Honor, I don't know, I don't recall in the Court of Appeals opinion that says magic words need to be used. I recognize my friends at the table are arguing they were requiring it and they're reading into that. I will admit that there are some more things in the Court of Appeals opinion that would help distinguish, for instance, why it was vacated, the TPR, sorts of things that would guide us a little bit better. But what also my friends have also pointed out is Respondent has not challenged a lot of facts. I think they noted 2 were challenged. The problem, the inherent problem in these cases is how do you challenge a finding of fact that wasn't made? This case is about what's missing. It's about how do we have a finding of fact that tells us the issue embodied. Again, going to LRLB, as this court noted, specifically noted that trial court actually did note, and if I may, aside from acknowledging Respondent mother's attendance at the October permanency planning hearing, referencing her absence from the March, somewhat not exact, Your Honor, but it still found, that still says, did not address the issues embodied. The problem, I think, that this case creates, and the problem that this line of cases creates is, what does the trial court need to do exactly? And here, the Court of Appeals has looked at it and said, you haven't done it. Your Honor, I must concede. Other than saying you need to go give these specific things, there is not specific language in the Court of Appeals that says exactly why it was not sufficient. Again, Your Honor, the problem that I had is how do I prove the negative? It's not there. And that's why we're here today, because they agreed with that. And appellate courts can't be fact finders. As my friends have pointed out, the dissent, specifically we'll talk about availability, said availability wasn't the issue. If that were finding a fact at the trial level, I think we would have a different case before us. But that's not. That is an appellate Court of Appeals judge saying, I don't think availability was the issue. They've also brought up, again, I think timeline is incredibly important. They also brought up, and I believe the phrase was a procedural turning point was in 2021 with the disruption of the trial home placement. But efforts with the mother weren't ceased until April of 2023. I don't view 2021, July 2021, as a turning point. Because if it was, then I think it raises the question of going deep into the facts as to then why did the trial court not cease then? What else was going on as to why they continued to have reasonable efforts? And I think the difficulty is continuing to try to look at deep into the facts, and that is not what we're to do here today. That is not what the Court of Appeals was to do. The trial court was supposed to do that, and they did not make clear in their order what exactly the issues were. There is no guidance on the exact language. There is, however, guidance from 906.2D as to what needs to be considered. So while I'm not advocating for the verbatim language, and possibly mistakenly may even go a step further, that even the verbatim language of the statute wouldn't do it, because as this court has said, it's the issue, it's the embodiment. What is the essence of what it is? And what is the court considering? And these findings of facts from the April 2023 order do not tell us what they're really considering. They do not tell us whether or not they really considered it. And the statute requires, and no case law from this court has ever said they cannot not consider it. Case law says you can consider it and then make a decision to not make a written finding about it. I believe the clarity of the record and the clarity of the order still needs to tell us that they considered it. That is, again, the difficulty with cases like this, is how do you get that finding other than someone saying, I've considered this. This is exactly what I've considered under this. Again, not specifically advocating for specific language, but I think, as I've thought a lot about this, is how do you handle not needing to make findings about everything, but still making sure a trial court's doing it? Because otherwise, if we don't have that, if there isn't a rule that states it needs to be clear on the face that they have, in fact, considered all of the factors, I think that very much opens the door to a permanency planning hearing ceasing reunification that has 0 factors. If I may, it would have no findings whatsoever, and then allow someone to then step forward and say, well, the trial court, based on that, must have just assumed that none of them mattered. We can also draw a distinction in N.M.W that I think may guide on how this case is different. In that case, Your Honors, that was an unexplained injury case. And I don't have the quoted language, but I believe Your Honor said, moreover, our own precedent requires that we look at those findings, or those findings are sufficient for an unexplained injury. Again, my friends have pointed to, well, 2021 is the big issue. But unlike an unexplained injury case, where a parent's repeated failure to say what happened or take any responsibility or any of the other factors of which I think that distinguishes N.M.W from this case. It's way too complicated. It's way too nuanced. The record is large, but it is not cut and dry, as petitioners tried to put forward. It is not that in 2021, when trial home placement ended, this case took a procedural turn. And we know that because it was almost 2 years of alleged continued effort from the department before they even ceased reunification. And the TPR was actually already filed at that point. So for those reasons, I don't believe the Court of Appeals has gone outside the precedent of N.M.W. They just did.
Do you think, I'm sorry to interrupt, but do you think that the Court of Appeals opinion provides sufficient guidance to the trial court?
Your Honor, I believe it provides guidance on what to do. In this case, it specifically vacates the order and sends it back and says that the county must provide the necessary, in this case, the necessary statutorily mandated services and hold a new hearing.
It doesn't, though, really explain why the findings of fact are inadequate, does it?
Your Honor, yeah, I would concur that the Court of Appeals opinion does not give guidance as to all future trial courts, as what needs to be in there for it to be sufficient. Again, I believe that's the inherent issue here.
So what's the trial court going to do with this in response to this? Don't you think it's going to say, boy, I better put the language, from D in my order?
Your Honor, as for this specific trial court, I believe, based on the Court of Appeals, if affirmed, they would hold a new hearing. And it's not guaranteed. I don't think we can now guarantee that they would intend to cease again. But if they were, in looking at what is now, because that was April 2023, we're 34 months away. If they did choose to cease again, then yes, I think that they would be more mindful, maybe look at the statute. But again, I think the guidance, I believe, comes from NRLRLB, which is the issue has to be embodied in it. You have to know, maybe that is some language of, I have considered and this is why I don't consider this, or this is why I don't consider that. But that, I believe, based on the case law, that's where we're at, is that has to be designated. Otherwise, appellate courts, as we see here, look at it, and if, in this case, Court of Appeals,
It just, I'm sorry, finish what you were saying.
I was just that the issue is when it's missing. Again, it's very difficult to show the negative. So here, this 2 out of 3 Court of Appeals judges found they don't see it, and there's no specific finding that guides them as to why it's missing.
It seems to me, though, to put the trial court in a very bad place, because on the one hand, we say, or you don't have to use specific terminology or magic words, but here the Court of Appeals has just said what you've done is inadequate without explaining why.
I concede that the Court of Appeals does not explain why they believe it's inadequate. As I put forth, I believe the continued issue is, how do you point to what's not there? Which challenge, again, the finding of facts, most of them were not challenged because the issue is what's missing. It's a daunting task for the trial court. I don't have the benefit of being trial counsel in this case, but I do trial work, and it's a daunting task for trial counsel, for Court of Appeals, for your honors, to come up with a law that is going to make clear to everyone while still ensuring that trial court is considering those issues, because NRA-LL does not stand for the idea that the trial court cannot consider something. They still must consider all factors. NRA-LL only stands for the idea and precedent that they need not make findings as to each and every one. And I guess concede that's a quite daunting task, again, to how to write that and draft that in a way that makes it clear to trial counsel. You don't need to do specific language, however, this is exactly what needs to be said. But I believe to not uphold the Court of Appeals and to allow it stand that they need not make specific findings, and we can just look at a permanency planning order and say, well, read into it and say, because the findings weren't made under 906.2D, therefore they must have considered it and determined it wasn't necessary to make findings. I don't know how practically that would be applied and how practically you would discern from a trial court that forgot to consider or did not properly consider 906.2D factors and a trial court that did in fact consider them but then found that there wasn't a need to write necessary findings without explicitly explaining that in their order in order to show, yes, I've considered these issues. However, I need not recite it all because I don't believe they're relevant. It is a difficult spot. I don't have a clear answer, except for in this case, I believe it falls short and the Court of Appeals was correct to send it back and to ask that the trial court begin anew at a new permanency planning hearing.
It just seems to me that it's very unhelpful for an appellate court to just say essentially, hey, you're wrong, and not explain why. It's unhelpful to the trial court, and it's also, I think, unhelpful to us as we try to review the Court of Appeals decision.
Again, I think this area, the fundamental guiding principle is the statute in looking at those things. I think I have conceded that there's could be more in the Court of Appeals that explain exactly why, but ultimately I don't think that undermines the ultimate fact or the ultimate conclusion that this was insufficient and therefore should go back to the trial court. So, Your Honor, for that reason, we do ask that you affirm the Court of Appeals and remand all the way to the trial court for a new permanency planning order and allow the vacation of both the permanency planning order and the subsequent TPR. Thank you.
Thank you, counsel. Rebuttal.
All right, thank you. All right, in rebuttal, I wanted to clarify one additional point, Justice Berenger. It's been 2 years since the termination order was entered, but it's been 4 years since they've had any visitation with their mother. Okay, I'd like to address a couple of points that Mr. Senjas made. First, you mentioned the delay between the time of the termination order being filed, the petition for termination being filed and the actual termination hearing. There were several delays that happened in that time period, but notably, a couple of those are related to the parents themselves. For example, a very large portion of time in that time period was, and I don't have the exact timeline in front of me, when Ms. Day herself sought to have a guardian ad litem appointed prior to the termination hearing. And there was a bit of time used to continue the case on for an extended period while they were determining whether Ms. Day should receive a guardian ad litem attorney for her. Another delay during that time was another example, and there are many on the record, of Mr. Wolford threatening his attorney and having to get a new attorney reappointed and up to speed on the case. As far as the findings themselves, Mr. Senja's referenced multiple times that you can't find something that's not there. It's there. It's there in the permanency planning order without using the word available. It's there especially in the termination of parental rights order. Termination of parental rights order goes on at length about all of the services that were offered to the parents and what they did and didn't do during the time that they were under the watch of the Department of Social Services. There's nothing that we can say is missing at this point except for the word available. And in response to, if I were in the trial court's position on a remand or a vacation, as the Court of Appeals suggests, I'd be putting available in my order. And that's precisely what this court has said over and over and over again is not needed. So while the Court of Appeals, we don't know if they made their own fact finding or not because they didn't give us anything to suggest they did or did not, it does seem to me that they did a reweighing of the evidence that was presented because the information is there. If this court were to wish to distinguish or clarify LL, this case isn't really the one to do it because the deficiencies that were noted in LL are not in this case, especially as it relates to availability. And especially, even though we don't need to get there, the ultimate reason that we are here is to give our children, in this case, a sense of permanency and in a reasonable amount of time, and this has not been reasonable for the life cycle of this case. I personally believe Mr. Senja's, mischaracterized my statements about the importance of the trial home placement as being the big issue. That was not my intention to leave that. There are a lot of big issues in this case. My intention was to point out that they've tried really hard. Everybody's tried really hard to make this work. And it didn't. And after it didn't, the trial courts continued to give additional time to the parents.
Thank you, counsel.